Hey, good afternoon, everybody. My name is Tom Dunn, and I am the Director of Business Solutions at TCIA. Thank you all for joining us for the second in a series of webinars TCIA will be hosting on important issues for your business related to the coronavirus. We will have the third one next Wednesday on cash flow strategies, which will be at the same time, 12 p.m. Today's webinar will cover key provisions of the CARES Act that are applicable to your tree care business. We will also touch on a little bit on insurance coverage. I am pleased to introduce our presenters today from the Hunton Andrews Kurth Law Firm. We have with us Kurt Larkin, who's a partner in the Richmond, Virginia office, Michael Levine, a partner in the Washington, D.C. office, and Brian Merrick, who is a partner in the Dallas, Texas office. Also serving as a panelist today is Aidan O'Brien, who is the Advocacy and Standards Manager at TCIA. So we are going to keep everybody muted, except for the panelists, and try to keep the background noise to a minimum. You will have the ability to ask questions anytime during the presentation by clicking on the Q&A icon and typing in your questions, and we will try to get to as many as possible in the allotted time. Our goal is to get out as much information as possible, and the panelists have made themselves available to respond to questions that are not addressed, which we will try to gather and post on tcia.org. So with that, I will turn it over to Aidan O'Brien and the rest of the presenters.
Thanks, Tom. So as Tom said, I'm TCIA's Advocacy and Standards Manager. And my major focus during this, the COVID-19 situation, is really working to get relevant information to all of our members. There's been a lot of unprecedented change and a lot of changes coming out of Washington, D.C. that really affect a great deal of our membership. So working with Tom Dunn to put on these webinars is one of the best ways we found to answer a lot of your questions and to get the right information out quickly and efficiently. And so I'm just going to talk a little bit quickly about the COVID-19 resource page we put on tcia.org. If you visit that website, there's all sorts of great information on how businesses are responding to this situation, specifically tailored to tree care businesses. So if you haven't checked it out, I highly recommend you do so. It's just on the homepage of tcia.org. And so again, we're here to answer your questions. So if you have questions pop up throughout the presentation, feel free to put them in that Q&A box on the bottom of the screen. And so now I'll turn it over to Mike Levin to kick off the presentation.
Aidan, thank you. And thank you for the opportunity to speak to the TCIA membership about COVID-19 and some very important issues that are relevant to your business and virtually every business out there, because we all are in this together, and every client, every business that we've talked to has experienced many of the same impacts as a result of COVID-19. The bulk of our talk today will focus on debt servicing and the CARES Act and workforce issues, but insurance is one of those things that cuts across every industry, every business. And we thought it was important to at least raise some of the issues that we are seeing and dealing with, frankly, on a daily basis for all of our clients that have been impacted. There's been a lot of talk in the news, certainly in the insurance industry, from insurance companies and insurance brokers, about how there is no coverage for losses resulting from COVID-19. And I'm here to tell you that's not accurate. Those are gross overgeneralizations, and they don't take into account the specific language of each insurance policy. And those of you that have read your insurance or attempted to read your insurance know that they are complex contracts. They are all generally different in one way or another. And the words in those contracts makes all the difference when it comes to finding coverage for losses like those that stem from COVID-19. So if nothing else, I would encourage you to read your insurance and talk to somebody who can help you understand what some of the words and phrases and coverages mean and where they should and shouldn't apply, because we are finding in almost every instance there is at least some coverage or a strong argument for some coverage, or even substantial amounts, millions of dollars of coverage, under policies that the insurance companies and the insurance brokers have said simply do not apply. The one coverage that I do want to touch on and I'm only going to take another minute or so before turning it over, is your commercial property insurance, because it contains a very important coverage for COVID-19, and that's the business interruption or business income coverage that applies to cover your loss in earnings, loss in profits, and the extra expenses that you were spending and incurring during this time of uncertainty and shutdown and restrictions through government agencies. That business interruption coverage can be substantial. Again, it can be millions, if not hundreds of millions of dollars of coverage available to cover your losses as a result of your inability to conduct your business as you had been before COVID-19 came on the scene. There are a host of other coverages that are potentially applicable, and I've included some 20 slides in the slide deck that will be available to you so that you can review those at your own leisure. And if you have questions, follow up with me, and I'm happy to talk them through, but I don't want to take up too much time today. Jumping through the 20 slides and to what I feel are the key takeaways from your insurance, take that inventory and understand what policies you have. Again, first and foremost, commercial property with business interruption and extra expense coverage is the one you want to look at first and foremost. Another one that we're seeing apply on a very frequent basis is pollution liability, which many of your businesses may also have. Understand the facts and the way that your business has been impacted. Have you had any employees or other people at any of your offices that have actually tested positive for COVID-19? That's a game changer in terms of insurance because it brings the actual contamination and potential damage to property onto your premises, and that triggers additional coverages under your policy. Know what the specific coverages are in your policy, and again, don't take the generalized no, the blanket broad brush statements from the insurance companies and the brokers that no policy applies. That's simply not true, and if you read the actual words of your policy, you'll see what I'm talking about. They are all different. Very important, notification of your insurance company of a claim. Most policies require immediate notice or notice within a certain time frame, often 30 days. So it's important to get that notice in now and not foreclose the opportunity to recover losses that you've already sustained or are currently sustaining right now. And then, finally, think about some of the companies that you are doing business with, your vendors, subcontractors who also have insurance, and their insurance may also apply to the losses you're sustaining. So those are the insurance issues. If you have questions during the course of the webinar, feel free to jot them down, and I'm going to stay on for the duration of the webinar. I'm here to talk to you offline as well. Thank you very much.
We can hear you.
Great. Hi, my name is Brian Mark, and I'm a partner at HUNTO. I primarily represent community banks, but I've been working with both lenders and borrowers to understand the SBA Paycheck Protection Program, or I'll refer to it as P3, which is administered by the Small Business Administration, or SBA. So I'm going to give you a brief overview. Much more detail on this and other COVID-19 related matters can be found on the HUNTO website and the COVID-19 Resource Center. This process for the loans is rapidly evolving. The SBA has been issuing regulations or guidance on this program just about every day for the past week. So please check the COVID-19 Resource Center regularly, and there are links at the end of our slides directly to those resources. You move to the next slide, please. Okay, so I'm going to talk about key components of the CARES Act, the Paycheck Protection Program, EIDL grants, and then the Economic Stabilization Fund. The Paycheck Protection Program, or P3 program, authorizes the SBA to guarantee 100% of the loans of lenders making loans to eligible businesses for loans up to $10 million or 250% of monthly payroll costs. It allocates roughly $350 billion to guarantee these loans to small businesses through the SBA 7A loan program. And before this program, the SBA guaranteed approximately $25 billion in 7A loan programs each year. So the $350 billion that the SBA is going to guarantee through this program is more than a 12-fold increase for what they normally do. These P3 loan programs really come into play. It covers the period from February 15th, 2020 until June 30, 2020. But Congress has the authority to increase the covered period until the end of 2020 if the need should arise during the pandemic. On the EIDL grants, they authorize emergency grants of up to $10,000 to eligible businesses, as well as loans up to $100,000. And then the Economic Stabilization Fund authorizes the Treasury Secretary to establish a loan program for eligible banks and other lending institutions that lend to mid-sized businesses. So if you could skip to the slide which starts which businesses are covered, please.
Okay.
So which businesses are covered? Well, it's any small business otherwise eligible for an SBA loan. And this is generally tied to the North American Industry Classification System, or NAICS code. Those codes can be found at naics.com. And the SBA has a regulation that lists almost every NAICS code and what criteria the SBA uses to determine eligibility. Almost all are based on either the number of employees or revenue or net worth of the company. So I would encourage you to check your NAICS code. There are different codes that may apply to your business depending upon which particular line of business that you engage in as tree cutters. So consequently, you can go to that NAICS website, type in tree, and then search for the specific activity that you engage in. In addition, there's an alternative that the SBA has said that any business can be treated as an eligible business if it has a maximum tangible net worth of not more than $15 million, and the average net income after federal income taxes, excluding any carryover losses of the business for the 2 fiscal years before the date of the application, is not more than $5 million. In addition, under the CARES Act, any business which employs 500 employees or less, and that includes both full-time and part-time employees, is eligible. Nonprofits are covered, as well as, subject to various exceptions, sole proprietorship and the self-employed. If you would move to the next slide, I'm not going to talk about the normal affiliation rules. So the normal affiliation rules do apply except in certain instances that I'll talk about. But the number of employees of affiliated businesses are aggregated for the determination of small business status for SBA loans. Affiliation rules are really too complicated to discuss in detail, but they'll pick up entities that have similar ownership or management. These affiliation rules are waived by the CARES Act with respect to loan eligibility for certain types of businesses. For hotels and restaurants, there's a waiver, except if they have 500 employees franchise is exempt from the normal affiliation rules, and any business that receives financial assistance from an SBA licensed company under the Small Business Investment Act. So next slide, please. And this is talking about the maximum loan amount. As I mentioned, it's the lesser of $10 million or 250% of the applicant's monthly payroll costs for 2019. Now, there are some special rules. Newly formed businesses may calculate the monthly payroll average as of January 1st, 2020 through February 29, 2020, and then average those 2 months. Seasonal employers can elect to use the average monthly payroll for the 12-week period beginning either February 15th, 2019 or March 1st, 2019. The maximum loan amount will be reduced by the amount of any emergency economic injury disaster loan, the EIDL loans that I'll talk about a little bit further later, provided to any eligible employer during the period beginning on January 31st, 2020, and ending on the date which any such loan is refinanced under the P3 loan program. Now, the maximum, the interest rate that's going to be charged on these loans is 1% fixed. All payments and interest will be deferred for the first 6 months, and the term of the loan is 2 years. The next slide, please. So the SBA has come out with a streamlined loan process. The SBA has relaxed the procedures in the typical SBA loan process in an effort to get this money out to the borrowers faster. There are additional lenders that can participate. So typically, banks and other financial institutions have to apply to be members to participate in the 7A loan program. But the SBA is streamlining the process, and all federally insured depository institutions, including banks and credit unions, are eligible to make these P3 loans. The SBA has provided an abbreviated application form for borrowers and lenders for the P3 loans. These forms require less information in order for the loan to be made. And the documents for funding the loans are still in process. The SBA has indicated that lenders can use their own forms, but have also indicated that they'll be promulgating a form of loan document to be used for the lenders. The next slide, please. So what are the allowable uses for the loan proceeds? Well, at least 75% of the proceeds must be used for payroll costs, which include costs related to the continuation of group health care benefits during the periods of paid sick, medical, or family leave, and insurance premiums, therefore. Employee salaries, commissions, or similar compensation. If you do have an employee that makes more than $100,000 a year, then that piece is capped at $100,000. The remaining 25% of the loan proceeds can be used for payment of interest on any mortgage obligation. You can't prepay a mortgage or pay, and the principal payment on a mortgage obligation doesn't count towards the use of loan proceeds. It can include rent under a lease agreement or otherwise, and utilities. And then interest on any other debt obligations that were incurred before the covered period from February 20th to June 30, 2020 can be included. The next slide, please. Now, as I mentioned, the SBA has created a streamlined process here. Under a typical SBA loan, the borrower is required to demonstrate its inability to find credit elsewhere. That's not true with respect to the CARES Act. However, the applicants must make a good faith certification that the current economic uncertainty necessitates the need for additional support for the applicant's ongoing operations. The funds will be used to retain workers and maintain payroll or make other covered payments. And the applicant has not received funds under this program or under the 7A program and does not have another application pending for the same purpose and duplicative of amounts applied for or received under the P3 loan program. So it's one loan to one borrower. The next slide, please. Now, in order to incentivize businesses to retain employees and encourage businesses to rehire back previously fired employees, the P3 loan program includes a loan forgiveness feature. And the loans will be forgiven based on certain expenses the company paid during the 8-week period after loan origination. So it's the same formula that I described earlier, that the use of funds can be made. So it's payroll costs plus mortgage interest plus rent plus utilities. Now, the amount forgiven is going to be reduced by payroll reductions due to employee losses for the covered period compared to the monthly average number of employees. So if you've cut your payroll, then it could potentially reduce the amount of loan forgiveness. Also, if you have reductions in compensation of greater than 25% overall during the most recent full quarter for which the employee was employed before the covered period. So it's designed to encourage you to keep employees on the payroll and keep their salaries and other compensation at the level it was pre-crisis. There is an exemption for rehires. If there's a reduction in the number of full-time equivalent employees or in their salary or wages between February 15th and April 27th, the reduction will be disregarded for purposes of calculating the loan forgiveness amount if the employer rehires those folks or eliminates the reduction in compensation by June 30, 2020. Next slide, please. Okay. Other changes applicable to the CARES Act. For any applicant in operation on or before February 15th, 2020, there's deferment, and the deferment will be provided for a period of not less than 6 months. The expansions of the deferment procedures applies both to the existing 7A loans and new loans made under the P3 program. Okay, next slide, please. The CARES Act temporarily amends the recently enacted Small Business Reorganization Act to increase the debt threshold for small businesses eligible to file under the Small Business Reorganization Act from roughly 2.7 million to 7.5 million. This temporary eligibility increase sunsets after 1 year, after which the debt threshold reduces to roughly $2.7 million, subject to any additional adjustments imposed by Congress. Now, bankruptcy filing under the SBRA simplifies the Chapter 11 plan process and allows small business debtors to retain equity under certain circumstances. It shortens certain deadlines in the case and eliminates committees of unsecured creditors in an effort to reduce costs. Now, the SBRA itself is only a few months old, so there's still questions about that process, but the increased threshold may be beneficial to borrowers here. The next slide, please. I'm going to talk about the emergency EIDL grants and loans. So in addition to the P3 program, Advances of $10,000 in the form of emergency EIDL grants are available to eligible businesses with not more than 500 employees during the period from January 31st, 2020 and ending on December 31, 2020 that apply for a loan under the SBA 7B2 program, which provides loans to eligible businesses in the amount of up to $2 million. The grant does not need to be repaid even if the EIDL loan application is subsequently denied, and can be applied to similar costs and payments as the P3 program. The next slide, please. Actually, before I move from that, I would mention if you do apply for an EIDL loan and subsequently apply for a P3 loan, the amount of the EIDL loan less the grant, the $10,000 grant, has to be refinanced in the P3 loan. But they are two separate programs, and you can proceed under either. In addition to the CARES Act and the Paycheck Protection Program, there are several other economic lending programs created under the CARES Act, and many of them relate to the Economic Stabilization Fund, which authorizes the Treasury to establish a loan program for eligible banks and other lending institutions that lend to mid-sized businesses. Next slide. So which businesses are covered by the Economic Stabilization Fund? I'm going to go over this at kind of a high level here because none of it really applies to your businesses, but it does apply to passenger or cargo air carriers and businesses important for maintaining national security or U.S. businesses. The Treasury can use the fund. He has broad authority to determine the terms, conditions, and rates of the loans or loan guarantees, but there are restrictions on the duration and rates of loans or guarantees and additional conditions depending upon the company's industries and whether the companies are publicly traded or privately owned. Next, please. The provisions of the fund are earmarked for certain covered businesses. $29 billion to support passenger and air carriers, $17 billion for critical national security businesses. Now, unlike the Paycheck Protection Program, there's no loan forgiveness relief under the Economic Stability Fund, and loans or guarantees granted must be treated as indebtedness for the purposes of the Internal Revenue Code. The next slide, please. Any eligible business may apply to these programs, including a direct loan from the Federal Reserve. The CARES Act does not set forth the economic terms of these loans, but businesses are required to restrict certain operations during the term of the loans and for 1 year after their repayment. Specifically, they can't repurchase their own stock or pay dividends during those periods. There's also restrictions under for total compensation under those economic stability funds. The Treasury does have assistance for mid-sized businesses that they can implement subject to certain conditions, and I think Kurt is going to drill down on a couple of those things in his presentation. And then finally, the Federal Reserve may also establish a Main Street lending program that supports lending to small and medium-sized businesses on terms that are consistent with Section 13.3 of the Federal Reserve Act. And with that summary, I'm going to pass it on to pass on the presentation to Kurt Larkin.
Thank you, Brian. We're going to shift gears here and speak about some of the labor and employment issues that are implicated by the pandemic and how they impact your businesses. And I'm going to talk about both businesses where you've had to close and those that are still continuing to operate. So wanted to start and talk a little bit about the Families First Coronavirus Relief Act. The Labor Department put out an interim regulation implementing the act on April 1st. That is available on the Labor Department's website, and I would encourage you to go and review that, as it provides a lot of detail. I want to talk about some of the clarifications to the statute that they made in the guidance, but before I do that, let's just quickly recap what is the available benefit under Families First. Well, as you probably heard already, it does two basic things. First, it requires employers to provide paid sick leave of up to 80 hours for employees who have to miss work for pandemic-related reasons. Second, it expands the Family Medical Leave Act to allow folks who have to care for a child who's out of school or unable to access child care because of the pandemic, allows those individuals to take up to 10 additional weeks of leave under the FMLA at 2/3 of their pay. And you can see in the slide that there are daily and overall maximum limits that you'd be required to pay to employees who utilize either of these benefits. Now, the question that I've been getting the most from clients is how to determine whether my business is covered, right? The statute applies to businesses with fewer than 500 employees, but there are a fair number of ins and outs to determining how you count that number. And so here are some of the key criteria. And I think what's really most important, because as this law came out and went into effect on April 1, there have been a lot of businesses that have already, unfortunately, had to implement reductions, furloughs, layoffs, temporary reductions in hours. And what's important to bear in mind about calculating your eligibility under Families First is that you measure your workforce as of the date someone requests the leave. And so employees who've previously been laid off or furloughed don't count. Now, I know that there are a good number of you who have fewer than 500 employees, but that there may be some of you who have a larger workforce. And so this would come into play specifically for you. If you've had, for instance, if you have 600 employees and you had to lay off 200 of them, and following that layoff, someone requests leave, you can't count the 200 that you laid off as your employees. So at that point, as of the point the leave was requested, you'd have 400 employees and you'd be covered by the Families First Act. You also don't count individuals who are bona fide independent contractors. And of course, that is determined by the FLSA's test for whether someone is an independent contractor. You do count temporary employees. So if any of you happen to work with a temporary labor supplier who may supply you with day labor, they count in the calculation. And one other thing, and this may be pertinent to some of you, it's certainly been pertinent in other industries. You can't combine separate companies to get over the 500 employee threshold unless the companies are bona fide joint employers under the Fair Labor Standards Act, or they meet the FLSA's integrated employer test, which, without going into a lot of detail, is fairly similar. Now, the question that we've been dealing with on that count is it a good idea to try to avoid coverage by combining with, for instance, a parent entity or a sister company or an affiliated company and say, well, we're a joint employer and, the total of our employees together exceeds 500. Of course, every situation is different. And there are different reasons and maybe good reasons for doing something like that. But as a general matter, we don't know that that's the greatest idea. And the reason is because it could come back to bite you or the company that you are attempting to affiliate with if you have a parent entity later in a lawsuit, for example, for unpaid wages, discrimination, labor violations, where a plaintiff or a charging party names that other company as a joint employer and says, well, you considered yourself joint employers for purposes of Family First coverage, so you're joint employers for purposes of my Title VII claim. So our point is that you need to be careful if you're in a position where you might consider that type of approach. Okay, a few other points on Family First. The benefit doesn't apply if your business is closed. We have a lot of businesses who have just had to close down, particularly those that are not essential under state and local shutdown and stay-at-home orders. Businesses have to be running in order, and the employees have to be employed in order to claim the paid sick leave benefit. If they're terminated, laid off, or the business is closed, the benefit isn't triggered. Now, the Labor Department's regulations that were recently issued clarified that the expanded FMLA benefit, the extra 10 weeks, may be taken intermittently. So you would treat requests for intermittent expanded FMLA leave for child care or school purposes the same as you would treat any FMLA request for intermittent leave. Now, there are some unanswered questions. Can an employer, for instance, require this expanded FMLA leave to be burned concurrently with other provided leaves like PTO? We've got a little bit of conflicting guidance on that. The frequently asked questions documents on the DOL's website suggests that an employer may require employees to do that, to burn their paid leaves. But the final rule suggests that traditional substitution principles don't apply to the expanded FMLA. Now, that's a little bit contradictory. That's something that perhaps they may clarify in future guidance, but at this point, we're advising our clients that you probably shouldn't require paid leave like PTO to run concurrently with the expanded FMLA benefit. The one potential solution, if you're faced this problem, is to have the employee and the employer mutually agree that the paid leaves can be used simultaneously. Now, one other point on Families First, and it's sort of a general point, and this has been, frankly, the majority of my discussions with clients, particularly over the last week about this benefit. There's an exception there are several exceptions, but the one that could theoretically apply to some of your businesses are for emergency responders. And that includes, in the DOL regulation, businesses that do public works projects and those that operate specialized equipment to provide aid in a declared emergency or that provide services to maintain operations at healthcare facilities. Now, so you might ask, does that definition apply to your businesses? Now, of course, I wouldn't make a blanket observation on that question on a webinar because certainly the facts matter. But I raise it to suggest that if it is something you're thinking about, regardless whether the exception applies, it may be worth considering complying with the paid leave provisions of the Act, even if you qualify. Now, why do I say that? This is what I've been seeing from clients of mine that definitely qualify for that exception. As the pandemic wears on, it's been going on now for a while, and I think we all expect that it's going to continue for a while. But as it continues, I think that more and more employees are going to be wary of coming to work, any work, for safety reasons. We have been inundated with calls articulating this concern in union settings and non-union settings in all different types of industries, that employees are afraid that if they keep coming to work, they're going to get sick. and that this fear is interfering with the ability to operate, particularly if you're an essential business under a state and local order and you're allowed to operate. So the thought here is that businesses that remain operational throughout this outbreak are going to have to increasingly ensure employees that it's safe to keep coming to work. And one way of doing that is incentivizing your employees who are sick to stay home. And so the point that I make here is that if it's economically feasible, providing paid sick leave is one way to do that. And so it's worth a conversation as the situation unfolds if you find yourself in that position. And there's a bonus to taking that route. Of course, it's that the government will give a tax credit to businesses that pay the leave. And the new DOL guidance that came out over the weekend confirms that if you pay the tax credit, even if you may fit an exception, if you pay the leave, even if you fit one of these exceptions, you'll still get the tax credit. So it's a win-win prospect for your employees and for your business. Okay, I want to turn now to the unemployment provisions in Title II of CARES Act. So the Labor Department also put out new guidance on these provisions late last week and over the weekend. That guidance is available on the DOL's website under the heading Unemployment Insurance Program letter numbers 14-20, 15-20, and 16-20. I would encourage, again, you to review that guidance. There's a lot of detail in there. Now, it's primarily geared towards helping the state unemployment offices, who, of course, are going to be the primary driver of all of the claims, get set up to process the various benefits laid out in the CARES Act. But the guidance confirms a few things about how the program is going to operate. And so I wanted to talk through those with you now. It's important to understand that the CARES Act sets up two different programs that are designed to work in parallel. So let's talk first about the first program, which is a supplement to the existing state law unemployment insurance processes. So this first program that's found at Section 2104 of CARES is intended to act as a supplement to state unemployment. It basically authorizes states who enter into agreements with the federal government, and all 50 states have agreed to do that, to pay individuals who are otherwise eligible for state unemployment compensation an additional $600 a week. This benefit is available beginning the date on which each state agrees to participate in the program, and again, they've all already agreed, ending on July 31st of 2020. Now, the DOL made an important clarification over the weekend on how this is supposed to work. So to receive the $600 federal benefit, an employee must be eligible to receive at least $1 of state unemployment benefits for a given week of employment, according to that state's calculation methods. Individuals who are not eligible to receive the $600 individuals are ineligible, to receive the $600 benefit if they're ineligible under state law. So the bottom line is, if you're eligible under state law, you get the $600. If you're not, you don't. So that makes it a little trickier if you have a business that employs employees in multiple states and you're looking at a furlough or a layoff program to determine whether your program is going to impact your employees' ability to collect this enhanced benefit. We'll need to look at a state level to make sure that whatever you put in place is not going to impact that. Now, the second part of this first program is called emergency unemployment assistance. Most state programs pay benefits for up to 26 weeks. Now, Section 2107 of the CARES Act extends this period by up to an additional 13 weeks for individuals who've exhausted their right to state compensation but are able, available, and actively seeking work. Now, the DOL is encouraging states to be flexible in deciding whether someone is, quote, actively seeking work, but may be hindered from doing that because of stay-at-home and other closure orders in their area. So if you qualify for this extended benefit through July 31, the benefit amount would include the $600 additional benefit under 2104. After July 31st, the amount goes back to whatever the individual is qualified to receive under state law. And both of these benefits sunset on December 31. So the key, again, with this program is that determination of eligibility depends on the criteria of the state in which the employee is applying for unemployment. One other important clarification that, again, I think became evident this weekend in the DOL's guidance is that the $600 payment is not prorated based on part-time employment or based on the amount of income you earn. If you qualify for $1 of compensation under the state's methodology for calculating payment, you get the entire $600 federal supplement. Now, in many cases, this is going to result in workers earning more during weeks of unemployment than they may work or what they may earn while working, and that would be particularly the case with part-time employees. And there was actually some debate during the passing of the act as to whether the government actually intended that result. But I think that the Labor Department's guidance this weekend makes clear that that was the federal government's intent. The program is designed to provide extra assistance to households who are dealing with unemployment right now. So that's a very important clarification. Now, the second program, the 2102 benefit, is intended to also provide up to 39 weeks of benefits. And this is a brand new federal unemployment benefit. And it's designed to kick in for individuals who are not eligible under the first program. And examples of that might be independent contractors, folks who work in the gig economy who are often ineligible for unemployment benefits, or employees who've exhausted all other rights of their 26 weeks under state law. So this program is also intended to run for up to 39 total weeks. The eligibility rules are a little different. Now, to qualify under 2102, individuals have to certify that they're available and able to work, but that they're either unemployed, partially employed, or had to quit their job, or are otherwise unable to work due to a variety of COVID-related contingencies. For instance, they were diagnosed with COVID. They were sent home by their employer because they were symptomatic. They had to stay home to care for a family member who has it. Individuals who are able to telework with pay, who are already receiving paid sick leave, are not eligible. So if you qualify, the benefit is likely to be the same as the benefit under 2104. You would receive an amount equal to the unemployment benefit that you qualify for in your state, plus an additional $600 a week through the 2104 program. And again, that runs through July 31. And again, if you qualify, you get the entire $600. It's not prorated. And this benefit is going to be available, and it's available now for weeks of unemployment that begin on or after the week of January 27th, and the program sunsets again on December 31. Now, this CARES statute greatly expands available unemployment assistance, but it has raised a fair number of questions, and we've gotten a fair number of these questions from our clients. I think that the DOL's guidance that came out this weekend answers some of these questions, but not necessarily all of them. So we've been getting the question, if we lay our employees off, but pay them, we don't want to lay them off and pay them nothing. We want to lay them off and pay them a stipend, a portion of their wages, a portion of their salary. How's that going to affect us under this CARES program? Well, I think the guidance that has come out this weekend has pretty much clarified that the $600 benefit is going to be paid based on whether someone qualifies under the state unemployment formula. So the answer to the question, if I pay them something, are they going to lose the $600, is going to depend on whether paying them something would disqualify them under the state program. Many state programs provide for partial payments based on reduced wages or reduced earnings or partial work weeks. And so if your salary supplement or your wage supplement program that you're doing in connection with a furlough causes that person to earn too much under the state program, they're not going to get the $600. So that's something that you're going to need to take into consideration when considering those kind of programs. What about if the business isn't closed, but you lay people off? It's unclear. That's one that it's still unclear whether employees are eligible for the federal pandemic assistance. They may still be eligible for state benefits, which would arguably entitle them to the additional $600. But again, that's a question of state law. And the DOL did clarify this weekend that having to quit under 2102 means ceasing your employment involuntarily. For example, if you contract the virus and you're out of work for so long, or you're physically compromised to the point that you're unable to return to work. So again, I would, there's many more questions and many more clarifications in the guidance. I would encourage you to go and review the guidance because there is a lot more that's covered than this. And we're of course happy to answer questions that you may have on any of these points offline or if we can here at the end of the program. The last thing I wanted to touch on was the CARES Act's mid-sized business loan program, only because of the labor and employment provisions in it. If you're unable to secure adequate financing through some of the things that Brian was discussing earlier, Title IV of CARES authorizes the Treasury to establish another loan program to businesses employing between 500 and 10,000 employees, again on very favorable loan terms. But as you can see from the slide, there are some very significant strings that come along with that program, including that you'd have to remain neutral in a union organizing effort for the life of the loan. So my only point in mentioning this here at the end is that if your borrowing needs can be met through Paycheck Protection or some of the other vehicles described in CARES, then you don't have to worry about this part of the CARES Act. But those other lending programs are not able to satisfy your needs, or they're overwhelmed or exhaust their funds, or you don't qualify, there are businesses who may need to be turning to this program. And before you do, we want to just make sure you're aware of some of these provisions that are in the program. Now, I had some slides about collective bargaining, but I understand that there's really not a lot of union representation in the group, so we're going to skip those.
Yeah, I think, Kurt, I think this would be a good time to see if we could, and Aiden, to address some of the questions that the participants have. And
Sure.
we can go a little bit past 1 o'clock. We won't go too long, but maybe we could address some of the questions, Aiden. No, Aiden? All right. I can see the questions, so I'll ask some of them too. That any of you guys could answer. For PPP, do subcontractors count as payroll?
So for purposes of the P3 program, anybody who is, if an employer pays someone as an independent contractor, they are not included as part of the compensation or the payroll costs of the employer. The idea being an independent contractor can apply separately to their lender for a P3 loan. And so that payments made to independent contractors are not included in the employer's calculation of payroll.
Okay.
Hey, Tom, sorry about
yeah.
that. I had some
No
technical
problem.
difficulties. But I saw one that jumped out to me that I've actually been getting. I'd like to ask is, I'll
Sure.
paraphrase a little bit, but part of the P3 loan certification when you apply is that current economic uncertainty makes a loan necessary. What evidence are lenders looking for when they ask for that certification, if any?
My understanding is that is simply a certification that has to be made as part of the application. The lender is not required to do any diligence on the response received from the borrower on that question. And so consequently, I think most lenders are accepting the answer by the borrower at its face value.
That's great clarification. Thank you. So another question I've been hearing is, are there penalties for applying for the P3 loan and having it be available for if or when my business may need it? Because we're hearing some worries about funds that may not be available, as these are first come, first serve.
A couple of things about the P3 program. The $350 billion is first come, first served, and it will be determined by applications received and submitted to the SBA. In addition, recognize that the lending period for the P3 program is really short. All of the P3 loans have to be submitted and approved by June 30 to the SBA. That right now, that's the date that this program discontinues. So it's first come, first serve, but no later than June 30.
Is there a requirement for keeping employees on the payroll after the 8-week loan forgiveness period is over to receive that forgiveness?
No, it's going to be measured off of that 8-week period that begins the day the funding is received by the borrower and ending 8 weeks thereafter. So there's nothing that is required of the borrower after that 8-week period.
Okay. Pivoting to FFCRA, what documentation will be required under FFCRA to receive that tax benefit?
Yep. So that's a good question. That is covered in the DOL's final reg at section 826.100. If you're inclined to wade through this, but you don't necessarily have to. The employee doesn't necessarily have to provide a doctor's note. They are required to provide their name, the dates for which leave is requested, the qualifying reason for the leave, and the reg says an oral or written statement that the employee is unable to work because of the qualified reason. Now, could that be a doctor's note? Absolutely. But does it have to be a doctor's note? It at least appears under this guidance that it doesn't.
Hey, Kurt, I just had a follow-up on that question. Do I need to wait for an employee to ask for Families First compensation, or do I have to automatically offer it to them?
Well, I think that if you're a covered business, then you have to provide it. Now, the Labor Department has put out an employee rights poster that they're asking covered employers to post. So presumably employees be aware of their right. I think sort of the rule of thumb on this is to err on the side of caution, and that if you have an employee who calls out of work with a diagnosis of coronavirus, or you send them home because they are showing symptoms, and you have made the determination as a business that you're covered by the statute, I would pay it.
Okay. Well, I think this might be a good place to stop the session. I know some folks have some unanswered questions, but as they said, they would be available for you guys, and we'll try to collect questions, or you can contact directly. Thank you to everybody for participating, and be sure to check the tcia.org COVID-19 page for updates, and stay safe, everybody.
Thanks, everyone.
Thank you.